Good evening. My name is John Pankau. I'm an attorney. My office is in downtown Itasca. If anybody's been downtown Itasca, you know where Tree Guys Pizza is. Well, Tree Guys Pizza is like a landmark in town. We are right next to Tree Guys Pizza. You can't find our office because you have to go buy Tree Guys Pizza, park in the parking lot, then go up the stairs and come in the grocery store. And when I'm telling you come in through the grocery store, you really do come in through the grocery store. Our entrance to our office is through Matt's Market, which is a 100-year-old grocery store. So that's how you get in. Delia is an attorney, works in my office. We can't get the clicker to work, so Delia's going to be our clicker person. So let's go ahead and click to tell you. We're going to be talking about wills, trusts, probate, joint tenancy, powers of attorney. So pretty basic stuff, but we're going to try to keep it moving along so keep your interest up. Okay, let's go ahead. Last will and testament. Go ahead. Okay. People come in all the time and they go, what is a will? What do I need a will for? Okay. Legally executed set of instructions identifies who you want to inherit your property. It's simple. It's inexpensive to file. Actually, the county doesn't even charge for filing a will these days. It's mandatory under state law now. They've raised it, believe it or not, they've raised it to a felony if you fail to file a will within 30 days, which I thought was amazing. But it's a way of forcing people to bring the will into the county. One of the biggest things that we talk about with a will is the waiving of the requirement that a person have a bond, B-O-N-D. Because if you don't have that listed out in your, make sure you grab handouts. If you don't waive the bond in the will, it's necessary for the executor to actually purchase a B-O-N-D, a bond from an insurance company. So you don't want to have to force your executor to go through that expense. It's a big deal. It identifies who you want to inherit your property. Everybody is under this misconception that they have to leave their kids something or they have to leave something, and you don't. You don't. The only person that has an absolute right under the will is a surviving spouse. So if your surviving spouse can renounce the will, and by law take a statutory share. So when would that happen? For instance, I had this happen a number of years ago. This lady wrote a will and had 3 kids and left everything to her kids. She had been divorced, right? So after her divorce, she wrote the will. 5 years later, she gets remarried. And she wouldn't listen to me. I said, you need to do a trust. And she said, why? I said, because your spouse can renounce the will. Well, she said, he would never do that. Well, what happens was she died at a relatively young age, leaving everything to her 3 children. And of course, her husband went and talked to some of his buddies. They're sitting around talking. And she had about $800,000-900,000. So it's a substantial amount of money. And he was going to be kicked out of the house and the whole bit. And his buddy said, what are you talking about? All you have to do is renounce the will and you get 1/3 of everything. And by golly, he went to an attorney filed a renunciation, and he got 1/3 off the top. In a trust, a spouse cannot renounce a will. So when do we see this a lot? We see this a lot in second marriages, where you've got each person has their own kids, and they say, I leave everything to my surviving children, but I want my kids to get my portion. We were talking about this earlier, where you've got what's very common is both parties own a house. And each half has, if you have a house, you can have it in joint tenancy, right? What happens in joint tenancy if the person dies? Who does it go to? The surviving joint tenant. Now, even though you've got a will that says he's got 3 kids, I've got 2 kids, and we want the house split evenly among the 5 kids, and that's what the wills all say, there's nothing to prevent the surviving spouse or the surviving partner from changing their will. So 5 years go by, they haven't heard from the other person's kids, all of a sudden they change the will, and now the will says I leave everything to my children because I haven't heard from the other guy's children in 5 years. So you have to be very, very, very careful when using a will for your, as your method of getting the assets down to your kids. Let's go ahead. It's no help if you become incapacitated. It only goes into effect after you pass away. A will does not replace probate. As a matter of fact, in order for a will to be effective, it has to go through probate. All heirs must be notified and the spouse can renounce. So what does that mean? All heirs must be notified. Under state law, even though you're not leaving anything to somebody, we have to send them a notice. And let's say you haven't seen a kid in 5 years, 10 years, 20 years, 30 years. There's still a legal heir under your estate. We have to send them a notice. Not only do we have to send them a notice, we have to send them a notice telling them that they're not getting anything, and then asking them to sign a release and send it back to us saying, yeah, I agree, I'm not getting anything. You know how many of those we get back? Yeah, zip, zero, zilch, right. And so this whole thing ends up costing a lot more money because of all these extra notifications and everything we have to send out. So if you've got a will and you're not listing if everybody's not getting everything, we still have to send out the notices to everybody. So be careful about that. Okay, and we're going to contrast that with a trust. Probate's the legal process. So it makes sure your will is valid, makes sure your debts are paid, ensures that your assets are distributed according to what you want them to do. It's the legal way to change title. It's also very useful for insolvency. So what does that mean? I've got, recently we had a case where the guy had $300,000 in assets. That's a lot of assets. But he had $500,000 in debts. So, that doesn't work out really well. So the state law has a hierarchy of who gets paid first in a probate. You know who gets paid first, don't you? Who? The lawyers! Come on, what do you think gets paid first? Who wrote the law, right? It's like, which kind of makes sense, because if you weren't going to pay your lawyer and the court fees and the court costs and all that sort of stuff, the administration expense, nobody would do it, right? So there's the top tier is funeral expenses, cost of administration, legal fees, publication fees, all that sort of stuff. They come off the top. Then you get down to like surviving spouse awards and children's awards and things like that. All the way down at the bottom are unsecured assets, like credit card bills and things like that. So it's a way of getting, administrating these things. That way at least the estate gets settled. The bills that get paid in a proportionate amount to whatever money is available, and it's done that way. The other thing that we do probate is the opposite end, where you've got a lot of money and you want to cut off the claims period. So we had a case where a guy had property in Florida, Tennessee, Illinois, Kansas, and had various trusts set up and all that sort of stuff. So we went ahead and filed a probate here in Illinois and gave notice to all known creditors that we are aware of. And there's a 6-month window that if anybody has a claim, they have to file it. And if they don't file within that claims period, they're forever barred. So in that case, we used it as sort of a shield to protect the surviving spouse and all the other heirs from claims that could come up years later if we didn't go through probate. So it does have its way. It also makes sure your will is valid. There's a presumption under the law that if you don't present the original will, you gotta have the original. If you don't come up with the original will, there's a presumption that the testator, the guy that drew up the will, has destroyed the original will. So we're right now filing a petition to the court to have a copy admitted. And the reason is because we want to avoid having to buy a bond, because the copy of the will said everything goes to my kids, and we can't find it. You can't find the original. So without the will, everything's going to go to the kids, because that's under the state law. So we're going to see if we can convince the court to allow us to administer the copy. We're bringing in affidavits from the attorney that drafted it and from people that knew him and everything, saying that that's what he wanted. And if we could save a couple $1,000s on saving the bond, we're gonna try to do it that way. Okay. Probate, 9 months to 2 years. I had a probate that went 13 years one time. That was a long time. Anybody can access the court files unless it's sealed. Not that easy to seal their case. Notice must be given to all quote-unquote interested parties. What are interested parties? Parties are the heirs, which are your lineal descendants, or if you don't have any lineal descendants, then your parents and your siblings, and if they're deceased, then your nieces and nephews and all those guys. Anybody that you owe money to is an interested party. So we have to send out notice to anybody any credit card bills, any doctor bills, any hospital bills, anyone that we're aware that you owe money to. Your mortgage bill, all that sort of stuff, we have to send that all out to them. It's very easy to contest. I've seen judges accept a handwritten letter that says, I hereby contest this will, I should get money. We had a case where the will, this was interesting, the will said, I leave everything to my living children per stirpes. My living children per stirpes. Per stirpes means that the children of the deceased child take their spot. But it said living children per stirpes. So now we have a conflict. Who gets the money? Do the living children get the money? Or do the children of the deceased child, and there were two of them, deceased children, do they take their parents' share? So we had to send out notice to everybody and then let the court make the decision. The decision is that the living children takes precedent over the per stirpes. So the grandchildren contested it, saying we should get our share, and they lost. So it's interesting. So you have to be very careful with words. The things that you wouldn't think about when this will was drafted like 50 years ago, before half of the kids were even born, and some of them, then passed away. Very interesting. Okay. We're going to be in probate if your probate estate is over $100,000. Now we're talking about probate estate, not your total estate, just the part of the estate that's subject to probate. So what does that include? That's going to include anything that's just in your name. So let's say you've got a car just in your name. And by the way, did you know that you can now do a transfer on death form with the Secretary of State's office? So that you say, upon my death, I want my car to go to XYZ. Nobody, you call the Secretary of State's office, they say they can't do it, but you can. There's a form that you can fill out with the Secretary of State's office to transfer your car upon your death. But anything that's just in your name, the value is $100,000, we get kicked into court. Friendship Village, isn't that the one over here in Schaumburg? Yeah, okay. Friendship Village. You buy into Friendship Village. You give them a deposit. You give them like $150,000 and they promise to give you back 85% of it or something like that after you pass away. A lot of times, sometimes, when they're doing this, you've got salespeople filling these forms out. So they don't necessarily ask you, who do you want to be the beneficiary of that money, right? So what do they put down? They put down your estate. Now we've got caught a couple times, now we didn't because we didn't do it, all of a sudden we had people call us and said, we called Friendship Village and the amount we're getting back is over 100 grand and they won't give it to us because it says it's going to our parents' estate. So if you know anybody that goes into a situation like that, make sure that they fill out who they want that refund to go to. Because if they don't properly fill that out, it's going to end up in court. So twice now we've had to go to court to do a probate, and the only asset was a refund from Friendship Village. So, and I love Friendship Village. I'm not, but you just have to be careful. If you own real estate, probate's probably going to be required. But we're going to talk a little bit about that because the state of Illinois has changed the law. You can now put a beneficiary on your house. Couldn't do that before, but now you can put a beneficiary on it. When do we talked about when's probate recommended? When you've got debts that you don't know the extent of, possible lawsuits, claims, or judgments. We talked about that. where we had an insolvent estate and an estate with a lot of money. Okay, we're going to talk about trusts. Why do we like trusts? First of all, spouses cannot renounce a trust. It really, really works well, especially in second marriages where you've got each party owns some. I've got kids, you've got kids. However, we buy this house together. I put half the house in my trust, half the house in your trust. If I die first, you can stay in the house under certain circumstances, and you have to be very specific. You can't just say you can stay in my house until you feel like leaving. You got to spell out under what circumstances. Who can live in the house? Can you have your brother move in with you? Can you have your sister move in with you? Can you have your girlfriend move in with you? Who's going to pay the bills? All that stuff has to be spelled out in the trust, because this now is, 20 years later is going to be interpreted by somebody that didn't know what your intent was. So you have to be very careful about that stuff. But a trust is while you're alive too, because while you're alive, if you get disabled or become ill, your successor trustee could step right in and take over and assist you with the payment of your bills, management of your assets, making sure things are done properly. So that's why we like these things a lot. A lot of times it resolves family conflicts. In there you spell out, I want my house to go to my sister Betty, or I want it to go to my daughter Julie because Julie's lived with me for the last 20 years and she's helped and taken care of me. And you put it in there so that the other 3 kids aren't upset with Julie, because now Julie's got this house, and they go, well, how come she got the house that's worth $30,000 or $300,000, and we got diddly squat? Well, because she's the last 10 years been helping your mom doing this stuff, and that's what your mom felt like doing. So you have to be careful. It minimizes the possibility of a will contest because we're not in court. Trusts are not decided in court. They're a private document. So we file the will, but the only thing the will says is I give everything to the trust. So the trust is the vehicle that distributes all of the assets, that manages everything. So let's go ahead. You can, in a trust, that's what I said, the pour over will. It's used with the trust. It pours all the assets into the trust. Go ahead. Testamentary trust. These things are cool. Okay, what is this? Testamentary means that it arises after death. So what's a typical example of a testamentary trust? I had this lady come in. Her financial advisor called me up and says, hey, come on over. I want you to meet this couple. Unbelievably dynamic couple. In their late 80s, just the nicest people you could ever meet. He was a firefighter, worked in Elgin. She was the lunch lady, passing out lunch to everybody in the local cafeteria and everything. Not high-paying jobs by any means, but they saved every penny they had. Didn't spend a penny. I don't know how they lived. Maybe she brought home food from lunch. I don't know. Anyhow, when they died, which she passed away, they had like $2 million. $2 million. That's a lot of money. Yeah. Now, they had one child. That's probably a big help, having only one kid. 2 grandchildren and 4 great-grandchildren. So, nice family. But she was very concerned. She says, we got a lot of money, and we don't want our daughter, our grandkids, our great-grandkids to get this whole slug of money when we die. So, and I'm very intent on making sure my grandchildren and great-grandchildren, particularly my great-grandchildren, get an education. By this time, the grandchildren were already pretty old. So what we did, we set up 3 testamentary trusts. The trust number 1 was holding some property up in Michigan, because they had this cabin up there that everybody loved except her daughter and the grandchildren. So she didn't want her daughter to sell it. So she said, I want to make sure that my cabin in Michigan is protected. So we set up a little trust to hold within the big trust. So think of this big trust, and then within that we had a little trust set up for the cabin. And upon her death, he died first, then she died, and so we titled the cabin into this little trust, and we put $200,000 into it. So to pay all the expenses for the next 20 years. So after 20 years, the property could be sold and distributed to the heirs. Number 2 was we set up all of the grandchildren, 4 great-grandkids. We set up that they could go to any college they wanted, and the trust would pay all of their expenses for the next 6 years. Wow, wow. You know, that's room, board, tuition, you know, the whole book, you know, books, everything, lab fees, everything, for 6 years. Now I'm explaining this to the people. I knew what was going on. Nobody else did. They all came in my office on Saturday morning. We sat down, we went through this. And the girl at the other end of the table had just graduated from high school. She's 18 now. She's going away to school. And she's starting to, wait a second. She's got the next 6 years of college paid for. Well, that was cool. And on top of that, the money that was left over after everything else, we were giving everybody $25,000 a year until all the money ran out. So this is going to last for a substantial amount of time. 25 grand's not going to change your life, but 25 grand's going to make your life a lot easier. You know, I mean, it's a vacation, it's a car, it's a lot less burden on you. You know, I mean, you can breathe a little bit. You know, it's enough money that it makes it a little bit easier. So think about that. You know, how cool setting up those testamentary trusts were. So, and it's been a number of years now. Believe it or not, the 3 boys, not one of them went back to school, which I thought was amazing. You know, but the girl finished up and she got her bachelor's degree, but the 3 boys didn't. I mean, I'm like, wow, what an opportunity. So anyhow, can do a lot of good things with it. You can hold money for kids until they get to be certain ages, like 25, 30, 35. Had a guy comes in my office and he goes, John, says, I can't get my daughter, you know, she doesn't do anything. We're going to hold the money till she's 90 years old. I'm like, you got to be kidding me, 90 years old. I mean, what do you mean 90 years old? You know, so I said, bring her in, let's talk to her, you know. So the girl came in the office, we're sitting around, we're talking, you know, then they left and he came back the next day and he says, well, what do you think? And I said, let's make it 95. You know, because, I mean, it was like, are you tricking me? I mean, I don't know what planet she was on, but it certainly wasn't the same one he and I were on. So, you know, it was totally amazing. So anyhow, so we did that, and we put the bank in charge of the money, and they've been paying her bills, and she's been going along in whatever planet, Neverland she's in. You know, I don't know. So anyhow, let's go ahead. Yeah. A land trust. Remember when some of us that are a little bit older, land trusts were the thing of the evil people that had all these properties down in the city, the slumlords. Remember that? You know, they were hiding behind a land trust, you know. Well, you can't do that anymore. If somebody's getting sued, the land trust company, whether it's Chicago Title or one of the local trust companies, they're going to roll over. They're going to tell you who the beneficiary is. They don't fight like that they used to anymore. But what we're seeing a lot of this now being used is to keep privacy. So instead of, because right now in Cook County, I can go on the recorder's website or on the treasurer's website, type your last name in, and find out what you own, what you paid for it. I mean, it's ridiculous the amount of information that's out there. It is. And that's how you get identity theft. Those old mortgages used to have Social Security numbers on them. And people could pull up the old mortgages and find your social. They've gotten rid of that, you know, but there's so much information. So we're seeing people right from the get-go buying property in a land trust. The land trust is the buyer. The land trust ends up executing the mortgage documents. They end up owning the property. Nobody even knows who's there. Now, obviously, somebody could follow you home and stuff like that, but they're not going to be able to search by your last name and find out what the property is. So we're seeing a lot of this. Privacy, protection from chain of title, discourages litigation, transfers ownership without probate. This was a big deal in Chicago because, you know, Chicago has a transfer tax. Even worse than a lot of the suburban ones. Elk Grove's got a transfer tax, but the Chicago transfer tax is $10.50 per thousand. $10.50 per thousand. You sell a property for $100,000, you're paying $1,050 in transfer taxes. So think about some of these properties down in the city, you know, that are selling for millions, especially the buildings and stuff. So what they used to do, is they would own Sears Tower, for instance. They'd own Sears Tower in a land trust. And what they would transfer was that the land trust would still stay the same. The Chicago Title Land Trust 4578. And you would be, you own 4578, and he wants to buy it from you. So you say, I will assign you the beneficial interest in the land trust. You pay me $100 million. Now you own 4578. So the legal ownership never changed title. Chicago Title Trust 4578 still owned it. But the beneficial interest, who controlled it, changed. Well, the city of Chicago didn't like that one bit because they were losing out on a huge amount of transfer taxes. So only in Cook County, now whenever we have a change of beneficial interest, we have to fill out extra forms saying who's changing, if it's going from you to you, then we have to special forms, we have to file a P-tax, which is a property tax transfer and all that sort of stuff. Once you get outside of Cook County, you can do it, but you can no longer do that in Cook County. So it's very, very interesting. Okay, these things are huge. Special or supplemental needs trust. The number of children, adults that have special needs, there's a lot of people out there that have special needs. And they're able to qualify for programs that are through the federal, state, local governments. And they really need these programs. But in order to qualify, they can't have any money. So, you're in this catch-22. You've got a brother, sister, niece, nephew, child that you want to leave some money to that will help them through their life, but you can't leave them the money outright because if they get that money outright, then they're going to lose all their benefits. Well, we don't want them to lose their benefits, so what we do is we set up a special needs or supplemental needs trust, and that's where we put the money. So we go over here into Bill Smith's Special Needs Trust, and then the money can go in there. We have a trustee in charge of it. It's not Bill Smith's money. It's not his. It's a trust money. The trust has its own taxpayer ID. But when Bill needs a new pair of shoes, or he needs a new pair of clothes, or he wants to go to Disney, and you can buy him a ticket, put him on a plane, have him go to Disney, pay somebody to go with him, but he can't get the money. You can pay for his expenses down there, you just can't give him the money, but we can buy things for him, allow him to enjoy them. We can buy a condo, he can live in the condo. We can buy a car, he can drive the car, but it's not his. So it doesn't count against his ability to qualify for special needs under the Medicaid programs. So this is used a lot. So if you know somebody that has special needs and they're an heir or something like that, don't leave them any money because it's just going to end up messing up all of their qualifications.
So it's just a matter of contacting whoever's in charge of the trust.
Right. So if his question is how do you administer it? So upon the death of the grantor, the person that sets up the big trust, they have this little trust inside, and they have a trustee that's going to be administering the trust for Bill Smith. The money goes to him or her, whoever the trustee is, or the institution, and then they obviously know who Bill Smith is, so they are monitoring his needs and visiting him, and they have a fiduciary duty to make sure he's taken care of. So they will see, and if Bill says, hey, I'd really like to go with the other parts of my family to on a trip, they can provide for that.
You can make a phone call.
Absolutely, yeah.
What if the person is not an adult?
His person's what?
The person is not, it's not 18 or over.
Well, okay, the question is, what if the person's not over 18? Then you don't need a guardianship, but you can still set up the trust for their benefit. And even if they're little guys, because at some point along the line, even now they're going to qualify for special needs. Because let's say you've got a grandmother. My mother is 100 years old. So, yes, she's amazing. I don't know how she does it, especially living with me. But anyhow, so let's say that she wanted to leave some money to, let's say one of my grandkids had special needs. And even though they were babies, we could set up a trust for that child today. That money upon her death could go into that trust even though the kid was under 18. So you can set them up well before the children are adults. So, okay. Pet trusts. Wow, what a unique thing. We can now have pet trusts. Yeah, Helmsley, yeah. This is to those, I have kids, you know. So I don't have dogs, I don't have cats. Every fish that I've had in the bowl has died within a week, so it's like, I don't think you want anything, you know. But I have some clients, before I left the office today, I was working on this trust, and these people have dogs, and they have horses, and they have a lot of money. And they love their dogs, they love their horses. So we have set up a special trust for the pets to take care of those pets until they pass away. And we're setting aside a fair amount of money. I mean, it's 6 figures to take care of those animals. So pets are expensive. Pets are expensive, especially the big ones, the horses and stuff. I mean, we put chips in them, and we put in there, you know, that they've got to take the animal to the vet, make sure it's the same animal. You know, this is an 87-year-old dog, right? No, because it's, you know, no. We figure out that people could try to work around this. So we built in there, they've got to have chips, it's got to be identified, it's got to be taken care of. But, and then upon the death of the pet, the money goes to whomever you want it to go to. So this is a big deal. So, you know, if you've got a pet, make sure you set up a pet trust. Okay. This is really nice. We have a lot of people come in the office. This is called a TODI, a TODI, Transfer on Death Instrument, TODI. Came about in 2012. A lot of people still don't know about it. What that does is you come to me and you go, John, you know, I've got an IRA and I've got beneficiaries on that. I've got a couple of bucks in a savings account and I've got beneficiaries on that. My daughter's on my checking account just in case I need her to pay bills. But I've got my house and it's just in my name, so I'm going to put it in my daughter's name so when I die, the house can go to her. Wrong. You know, you're not going to do that. Why would you not do that? Okay. Number one, when a person passes away, you get what's called a step up in basis. Step up in basis. So I paid, let's say, $35,000 for my house 50 years ago, right? Now my house is worth $335,000. There's a $300,000 capital gain, okay? If I put my daughter's name on that house, when I die, the house is hers because it's a joint tenancy. She doesn't live there. She lives in, you know, Schaumburg, for instance. So she goes to sell the house. They're going to say, is this your principal residence? She's going to say, no, it's not. So she would have to pay tax on that $300,000 gain. Big, big mistake. You don't want to do that. However, if she gets it through a TODI, transfer on death instrument, or gets it through a trust, or gets it through my will, or otherwise inherits it, she gets a step up in basis to the date of death valuation of that property. This also works for stocks too. So you don't want to put somebody on a joint tenancy just because you want them to get the asset. So she inherits it at $335,000. She sells it for $335,000. She puts $335,000 in her pocket, says, thank you very much, Dad, for being such a good guy, and goes on with her life, as opposed to getting socked with a $45,000 capital gain tax bill. So be very careful about the tendency to use joint tenancy as an estate planning tool. It doesn't work. Do a TODI. You can change it at any time. You can name a beneficiary. It does not have to be a natural person. You could leave it to a trust. You could leave it to anything. But a corporation, residential real estate only. Can't use it for commercial stuff. But this is a big, big, big deal. And you don't have to go to the Village of Elk Grove and get, you know, the transfer stamps. You don't have to do that because it's not a sale, it's not a transfer of ownership. It's just a TODI. That eliminates, his question is, does that eliminate probate? Absolutely. The house, this is slick. I mean, this is gone like mad. Yeah, and it's super inexpensive for the kids. or whoever the beneficiary is. They just fill out a form that says, okay, we agree to accept the house is theirs, they file it with the recorder, they can sell it the next day. It is fast, it's efficient, it's very, very effective. Our state legislatures actually did something good for us back then. So, my wife spent 20 years down there, and this was one of the last things she did, was get that passed. I was very proud of her to do that. So, anyhow, small estate affidavit. If your probate estate is under $100,000, probate estate under $100,000, we can use what's called a small estate affidavit. So it's a document that says the total probate estate, now remember, those are things that are just in your name. So we're talking, nothing, if it's got a TODI or if it's got a beneficiary, that doesn't count. So the total value of your probate estate has to be less than $100,000. We couldn't use it on the Friendship Village because they were over 100 grand. But if it's under 100 grand, we use a small estate affidavit. It's slick, it's easy, it works, and it's a good way to transfer assets, and it's fast. So you don't have to go through court, and it's a great thing to do. The person that signs for it, though, is liable. So, you have to be truthful about it. You can't, if there's disputes or if there are bills that need to be paid, you can't say, well, oh, there's no bills to be paid. Because if there are bills to be paid, you're saying there's no bills, you're personally liable and you're committing perjury. But it really, really works well. Okay. Joint tenancy. We see this all the time. Joint tenancy, ownership of the assets by two or more people. Each share passes to the other owner upon death. It's a great way to avoid probate. We talked about that. I had a case in the city where the two flats, we all know the two flats in the city, right? Mom and dad lived on the first floor, daughter lives on the second floor. Dad passes away. Mom and dad own the house. Dad passes away, mom now is 100% owner of the house. Now in this case, the daughter lived in the house, so it was her primary residence. So, as a primary residence, as a single person, you can have a $250,000 capital gain on the sale of the house as long as you've lived in there for 2 years or more, 2 out of the preceding 5 years, and not have to pay capital gains taxes. So mom puts her daughter on as a joint tenant. So, and the gain on the sale was going to be under $250,000, so she wasn't worried about capital gains taxes. So the daughter's like 40, 41 years of age. What does she do next? What's the most evil thing in the world? She falls in love. Oh no. Gets married to this 28-year-old guy, and all the girls up front are smiling, let me tell you. These guys, so he's like 13 or 14 years younger than she is. And so they're sitting there, and he goes to her, now they've been married like 2 years, and he goes, why don't we sell our half of the house and move out to the suburbs? She goes, what are you talking about, sell our half of the house? It's mom's house. He must have done some research. So he goes, no, it's not mom's house, it's yours and mom's house. So they actually, seriously, they filed a lawsuit against mom, and for what's called a partition suit, and under the law, she had to then sell the house or buy them out. She bought them out, and they gave her, for half of the money. Needless to say, she changed her will thereafter, but you have to be very careful because when you put somebody on as a joint tenant, that person gets ownership interest in that property. You put somebody on as a joint tenant on your bank account, that person can walk into the bank and take 100% of that money out, even though you never intended them to do that. So be very, very, very careful. They get a judgment against them. They can levy that bank account and take every penny out of it. So you have to be very careful. If you're a married person, you should own your house as tenants by the entirety. It's one of those few advantages, well, I shouldn't say that. There are a lot of advantages to being married after 51 years. Put that on tape, get that to my wife, would you? Okay, okay. But the tenancy by the entirety protects the non-bad spouse. So if, this Jason Van Dyke trial, right? If he were to get sued individually, and they get a judgment against him individually, and his house is owned as joint tenancy, they could force he and his wife to sell the house and they could take that entire house. Boom, gone. However, if he owned the house as tenants by the entirety, they could not force the sale of the house. They could put a lien against his half of the house, but his wife's half of the house would be protected because she had nothing to do with the wrong actions. Not saying that he did anything right or wrong. I'm just using that as an example. Yeah.
You have a land trust on your house, wouldn't that supersede this tenants in the?
Well, okay, if you have a land trust, you can own, within your land trust, you can own that as a tenant by the entirety. So if you're married and you can say, you have to look and see what it is, but you can now say within the land trust, it's going to be Mike and Susie's house by tenants by the entirety. So you can add that as part of the ownership of the land trust. So joint tenancy is a great thing. We use it all the time, but you have to be very, very, very careful about how you use it. Okay. Carl, we just talked about that. New estate, probate. Okay. This is cool. Federal estate taxes. This always messes everybody up. How much money can you transfer under the federal statutes without having to pay a gift tax on it? How much money can you transfer? So without having to pay a gift tax.
$10,000 or less.
He says 10,000. Anybody else?
15.
15. Do I hear 20? 25, 30. Okay. This is always misunderstood. That number that you're talking about is a reporting threshold. A reporting threshold. So that means it is 15,000. If you gift, if you're a single person and you give to that single person more than $15,000 this year, you have to report, I gave her $35,000, first 15 is non-taxable, is unreportable. The last $20,000, although, is going to reduce the amount of money that I can transfer at the time of my death tax-free. The amount of money that I can transfer at the time of my death tax-free. How much money can you transfer this year under the federal statutes tax-free at the time of your death? This year, you can transfer as a single individual $11,180,000. $11,180,000. What does this mean? This means that people come in my office all the time and they go, John, our grandson's getting married next year and he's got this beautiful fiance. We really want to help them buy this house, but we don't want to have to pay all these gift taxes, that we're going to pay him. We want to give him $100,000. I said, give it to him, because, do you have over $11 million? No, we got, $2.3 million. I love you, All that's going to do is reduce the amount of money. So we tell them, okay, you're going to. They have two people, husband and wife, giving it to son and his now wife. So that's 15, 30, 45, 60 grand. The first 60 grand is transferred without reporting. The next 40 grand, all that does is reduce the amount of money they can transfer at their time of their death tax-free. We gave them a gift of 40 grand. So what? Now when they pass away, they're under the $11 million threshold. They're under the state's $4 million threshold. So they can basically give all this money away. Of course, they have to worry about the 5-year look back for Medicaid, but forget that. So this is not, people always come in, I'm worried about gifting money. Don't be worried about it, yeah.
Do the receivers of that money have to pay tax?
No, nobody has to pay tax on it. You give them a check for $100,000, they get the $100,000, you report the difference between, on your tax return, my husband and I gave $10,000, $100,000 to our son. The first $30,000, 15 from each of you is without reporting. We gave him $70,000. It just reduces the amount of money you transferred at the time of your death. It just, so it's a combined gift and estate tax. You can either give it while you're alive or give it after you're dead. So, but it's yeah. One quick question, yeah.
That $4 million state gift tax.
Well, it's an estate tax, right?
Okay. So
But
if you have an estate over $4 million, you have to give some to the state.
right,
Even if you're transferring it in a will or probate or something.
right. The question is, the state of Illinois has an estate tax, and if you have an estate in excess of $4 million of property located in the state of Illinois. So you should make sure that if you have property, you may want to distribute it, some of it out of state. Then there's, buy something out of state, but I had a client who passed away, and he had property in Florida, Illinois, and Wisconsin, and about $5 million here in Illinois. And we had the stuff out of state, we didn't have to pay tax. And he was a Florida resident. So we still had to pay a tax on the $1 million over the 4 here. So yeah, it's important. Okay, let's go on. Gifting. If you're going to give money away, be careful. You lose control of it. It has some. If you're going to give money away, don't give away appreciated assets, because remember, if you give away an appreciated asset, you're losing that step up in basis. So if you're going to give somebody something, give them cash, or give them a stock that hasn't increased in value. Because if you give them a stock that's appreciated, when they sell it, they have to pay the capital gains on it, because they get your basis in that stock. So when gifting, don't give appreciated assets. Medicaid look back, we're not going to even talk about, but remember that it's a 5-year look back. It's a big deal. Okay. Powers of attorney. These things are super important. We have more problems with people not having adequately done powers of attorney. The banks of this world, and God bless them, we love them, have taken over because they're all under federal charters. They think they could do whatever they want. They are now ruling the world. I've had banks tell me that they do not accept powers of attorney unless they prepare them themselves. I've had banks tell me that they need to have their bank specifically named in the powers of attorney. We, at our office, add like 2.5 pages to the statutory short form power of attorney. We put in gifting, we put in digital assets, we put in the ability for Medicaid planning, we put in, if we ask people, I said, just tell us where you've got bank accounts so that your agent can access the money at Bank of America, BMO Harris. So we specifically mention the banks so that they know we really meant that you can access these monies. Yeah, so these things are important. They keep changing them. So one of the things that you would point, well, let's go flip to the next slide. This is a big deal. Power of attorney for healthcare. In the power of attorney for healthcare, you are appointing an agent to act on your behalf, and you're going to act on your behalf if you become ill. You're also indicating who you would want to be your guardian, because this is I was in court last Monday. We spent how many months fighting about who's going to be the guardian of a person. And last Monday we were set for trial. We went before the judge on pretrial, and we finally hammered out an agreement between the parties as to who was going to be the guardian, because he hadn't done a power of attorney for healthcare. In the power of attorney for healthcare, you indicate, I want Joe to be my guardian. So that would have been all over. But here now you've got contesting parties as to who wants to be the guardian, so we were able to work it out. So this is a big deal. We do, in our office, between like the end of graduation season and Labor Day, we do free powers of attorney of healthcare for young adults, just because we feel so strongly when they go away to college or they're out of the house now. Once you're 18, you're an adult. Your kid gets hurt and they're away from school. We get this has happened to more clients than I can tell you. They get this dreaded phone call, oh, Johnny just fell down and got hurt, and they're taking him off to one of the hospitals in town. Well, which hospital? Well, I don't know. How many hospitals are there in town? Well, there's like 4 of them. So what do? You're panicked. You call up the hospital. Hi, I'm Johnny's mother. Is he there? We can't tell you. Can't tell you if he's here. We can't tell you that he's not here because of the HIPAA rules. They're in violation of HIPAA if they give you any information. So what you need is a power of attorney for healthcare and a HIPAA release. So this is a big deal. The HIPAA release will allow you to talk to the doctor and let you talk to the insurance company. So make sure that you've got these. If you know anybody that's 18 or over, if you love them, have them fill these things out. And these have changed a bunch in the last 3 or 4 years. So powers of attorney for healthcare, big deal. Go ahead, yeah. Power of attorney for property, again, authorizing IRA transactions. I don't know if you could see that. Okay, you've got an IRA, right?
Thanks.
Okay, now you do, okay. Okay, so what happens? The people say, well, I don't care. My IRA is going to go to my beneficiaries when I die. Well, what if you don't die? What if you just get Alzheimer's and all of a sudden we need to access that money to pay your bills? How are we going to get that money? Well, we're going to get that money because we've given authority for somebody to access your IRA in their power of attorneys. We specifically mentioned it. If you don't specifically mention it, it doesn't happen. Because you walk in with the standard power of attorney for property out of this, the one that the state drafts, and you go to the bank, and they're going to say, it doesn't say it anywhere in here that you have authority on this IRA. Well, it says financial retirement plans right here on the front page. It says retirement plans. Can you read that? Yeah, that's right. It's a retirement plan. You don't have a retirement plan. Well, yeah, I do. I've got an IRA. What's an IRA? It's an individual retirement account. It's not a plan. It's an account. They don't honor it. So you've got to specifically say, my agent has the authority to access my individual retirement accounts. It's like, seriously, they're splitting the hairs like that? A retirement plan is while you're an employee. An individual retirement account is when you're an individual. So it's a big deal. Okay. Digital assets. Go ahead. I didn't even know what a digital asset was 5 years ago. I'm not even sure I understand now. These are huge. You've got to give your agent authority to access your digital assets, to get into your bank accounts, to get into your Facebook account, to get into whatever all those things are. You know, because if you don't do it, they can't get them. Because these companies are extremely reluctant to allow access to your accounts. So it's a big, big deal. So now on our wills, we put in that your executor has authority to access your digital assets. We put in a power of attorney for property that your agent has authority to access digital assets. We put it in our trusts that your trustee has the authority to access digital assets. I've had clients come in my office and say, my sister died 3 years ago, and we still get birthday wishes to her automatically generated by this, I don't know, whatever it is, Facebook or whatever, and because it's automatically set up, and we can't take her account down because we don't have the passwords and we don't have any legal authority to do it. So digital assets are getting to be a big, big deal. Go ahead, I think okay, keep going. Okay, you get the idea. Company websites, photos, online, genealogy, research. Keep going. Okay, definitely, you have to have a will, maybe a trust. Power of attorney for healthcare, power of attorney for health property. Should have should put HIPAA in there, Health Insurance Portability Accountability Act release. Those 4 documents, a trust would be a 5th one. That would be your capstone for the whole thing. 18 or over, I think you still need it. People still have assets even when they're young. Okay, go ahead. Update. Is it a good idea to review it every couple years? Absolutely. If somebody's passed away, you or your beneficiary get divorced, new children, new grandchildren, leave money for your pets. Oh yeah, we had one that says, I leave it to my grandchildren, Mikey, Joey, and Sally. Well, that was 30 years ago. Now we got 11 more grandchildren. You gotta either say, I leave it to my grandchildren, period, as a class, or get all their names in there. But if you only live three kids, those are the only 3 that are going to get it. So you have to be really, really careful about that. If you've recently purchased property, if you've got a trust, put it in the name of the trust. I have people call me, oh yeah, John, I bought a new condo. Can we put it in a trust? Well, yeah, buy it. When you buy it, put it in the name of the trust. Or better yet, let us represent you. We'll put it in the name of the trust. If you're thinking about nursing homes in the next 5 years, got to think about these things ahead of time because there's that 5-year look back. This is a big, big, big deal. So, that's getting to be more and more complex. Nursing home expenses are $7,000, $8,000, $10,000, $12,000 a month, depending upon it. One lady paid $19,000 a month for a nursing home. Her husband has Alzheimer's. He's a young, vibrant, strong guy, and the only way that he will be allowed to stay in the nursing home is because you have to have a male attendant with him 24/7. because he gets up and does stuff. So, yeah, $19,000 a month. Wow. Okay, go ahead. I think that's it. Okay, questions? And yes, ma'am, all the way in the back in the blue.
Briefly, you went by wills kind of quick.
Okay.
Do you need a special form? Can I write it on a piece of paper? Is it legal?
Yes. Yeah, if you want to do your own will, you can. It's called a holographic will. Is it a will? I mean, to do these things are not expensive to do. It's too easy to screw them up by not, by putting in that, my living children per stirpes or things, silly things that you wouldn't even think about. Yeah, but can you do them yourself? Absolutely. Would I suggest it? Probably not.
Can you also go back over what you said about a bond? You have to
Okay.
have a bond for a will?
That's an example of what you could forget. The state of Illinois requires every administrator or executor to have a bond, B-O-N-D. However, if you have a will, you can put in the will that my executor is not required to have a surety bond. Okay, a surety bond is where you have to actually go out to an insurance company, purchase the bond. They will still execute a bond payable to the state of Illinois. It says, I hereby bond myself to the state of Illinois in an amount equal to 1.5 times the value of the estate. But if you don't put in there the waive the surety on the bond, then they actually have to go buy one.
Okay, so I need to put that in the will.
Right.
And then they don't have to get it.
And I'm recently had a case where we actually are going after the surety company because the executor stole all the money. And that's why you have to have a bond. And in this case, we actually had a surety bond because the guy died without a will, and then she actually had to go out and buy the surety bond, and then she took all the money, and we don't know where she's at. So the surety bonds to ensure that the beneficiaries get paid the money that are their
get it
due.
now.
Yes. Well, this is-
So what if you have a sibling who's never been married and I'm thinking of the below 100,000.
Yeah.
But they have a lot of debt. Is there any responsibility that you then, like?
Okay. Her question is if she has any responsibility for her sibling debts, and the answer is no. You don't owe them.
Even if they name us as a beneficiary for anything?
No. You have no liability to anybody for your siblings. We're dealing with that in the office right now. So,
Just don't sign nothing.
yeah. Yes.
Does
I will.
my will, my will have to be notarized?
It has to be witnessed by 2 witnesses. I don't think, and I looked this up, and I don't see any requirement for a notary. It does need to be witnessed. So do you remember? I could double check that, but I don't think it has to be notarized. I don't think so.
But you said it has to be filed with the court.
After you pass away.
Oh, after.
After you pass away, right. A will has to be filed within 30 days after the date of death of the individual. Yeah. Any other questions? Yes.
How do you pick an executor?
That's a really great question. How do you pick an executor? You look for the person that's going to do the best job for you, that you trust, that's going to follow your wishes. You don't necessarily go with your oldest friend or your best kid or any of those things. You go with the person that's going to do the best job. And if you don't have anybody in your family, you go to a bank and say, will you be the executor of my estate? I know Itasca Bank is a small bank. They do a lot of that stuff. Some of the bigger banks won't do it, but a small local bank sometimes will do that. It's tough, if you don't have family. If you don't have family you trust. Yes, sir.
You briefly mentioned the pour-over will.
Pour-over will is a will that says when you have a trust, you still have a will. And because that's how your personal property gets put into the trust. It's a whole purpose, the beneficiary of the pour-over will is your trust. So it says, I give everything I've got to the trustee of the trust I've executed on September 19th, 2018. And then the trust takes care of the distribution. So that's how your personal property, your clothes, your little itty bitty stuff, the stuff that's covered under that small estate affidavit under 100 grand, that's how that all gets put into the trust. Then the trust takes care of the distribution of all of the assets. So the trust is the thing that you work out, that does the work out of all the distributions, not the will. That's why they call it a pour over will, P-O-U-R, pour over will.
But that's actually a trust.
That's only used with a trust, right. So you have a trust that pours the assets into it. If you don't have a trust, then you just use a regular will, you know. And the goal is not to have to go through probate, to keep your probatable estates under 100 grand if we can. Any, yeah, one more question?
Can your executor be your attorney?
I don't think, the question is, can your executor be your attorney? And my suggestion would be, I would not do it. We've been asked a number of times, and I don't think most attorneys will do it, just because it's too fraught for problems. You know, we would be the attorney for the estate, but we would not be the executor. So maybe some people would, I don't know. Yes, yeah.
If you have an attorney in the family, is it a good idea to use that attorney for your will, or should you go outside?
Is it a good idea to use a member of your family who's an attorney? I do wills for my nieces and nephews, you know, I mean, but they don't have much, you know. I've done it for some of my siblings, you know.
Somebody who is a potential heir.
Probably not. No, if it's a potential heir, my sister didn't leave me anything, so I know. So no, so yeah. But if it's an heir, you definitely don't use that you know, person to get any. No, absolutely not. Yes.
Can you give basic cost ranges for each of these things, or
Sure.
too specific?
Well, I mean, and I don't know what everybody's, you know,
Right.
but figure wills are going to be, you know, like probably between 700 to 1,500 generally, and then trusts are going to be in the 2s to the 3s, you know, depending upon the complexity, what's all involved, and that kind of stuff.
2s and 3s.
2,000, 2,500 to 3,500, somewhere in there, you know.
And wills are 700 to.
Probably 50. So I mean, you can have a trust within a will too, so that you can have a trust that kicks out let's say, you know, because we get young couples in and they say, well, gee whiz, I don't want to spend $2,500 or $3,000 on a trust. What can I do? I said, well, we do a will, and then within the will we kick out our trust at the end. If so, it saves them money. It accomplishes the same thing a trust would, but in order for it to become effective, it has to go through probate. So they're betting on the fact that they're not going to die, and if they do die, though, the kids are provided for. We've got a trust for the kids set up. But you know, 20 years later, they come back and they do a regular full-blown trust. So, yes, ma'am.
What if I have young kids and something happened to me or my husband? Where do they go?
The young kids? That's a good question. What do I do with young children? Number one, you want to make sure that you have a guardian that will take over upon, you know, the death of you and your husband. That's probably, the question is who, you know, is the biggest issue. Who's going to do it? And then you can set up a bank or somebody else to handle the money. So you would set up a trust for the grandkids, like I was telling you about, or trust for your children, not your grandkids, but that lady I talked about that had the 3 little trusts, that's what she did. Well, you know, just, you know, when my kids get to be 25, they get a portion. When they get to be 30, they get a portion. When they get to be 35. But I do want them to provide for my health, education, and welfare of my children. So you put that in, the trustee takes care of that. Now, the trustee does not have to be the guardian, because you may have your sister's this wonderful, great person with kids, but, you know, doesn't know anything about money, but you've got a brother-in-law that's a financial genius. So he can take care of the money, she can take care of the kids, they work out a deal. You know, I need $3,000 a month for the kids and that kind of stuff. But it's the biggest first question is who's going to be the guardian of the kids? Who's going to work, you know, take care of my kids? My kids, nobody would have taken them, let me tell you.
Look at your 5.
Yeah. Way in the back.
Sure, for someone who's the executor of an estate in Cook County, in the suburbs though,
Right.
and who needs additional copies of letters of office, do they have to go all the way downtown to get them, or can they get them from another quarter of the county, like Rolling Meadows or?
You know, I've never tried to get them. The question is, where do I have to get additional copies of letters of office? We always get them from the Daily Center. I don't know that you can get them from anybody else, because I don't think there are any other local courts that handle probate. So we just always get them. I mean, we just mail in for them, or we have a service that we use that goes over to the county building, picks them up, and we have to pay them to do it. But getting letters of office from Cook County is a hassle.
Yeah, especially if you have to go all the way down.
It is, yeah, it is. Yeah, yeah. Well, yes, ma'am.
So I have a question. Can you simplify the difference between having a will and the advantages of a trust? I still don't.
Okay, the biggest advantage of the will, the disadvantage of the will is it has to go through probate.
So I don't want that.
So it's time consuming. Probate's going to take anywhere from 12 to 15 months. Generally speaking, in Cook County, you're going to be 12 to 15 months. It's to get it done in a year is really fast, and it costs a lot of money. You're going to be spending anywhere from probably $6,000 to $8,000 to go through probate. You've got filing fees, recording fees, publication fees, all of those things that are very, very expensive. So the advantage of the trust, number one, a trust is private. Nobody get, you know, it's like a will is an open document. Anybody can read it. Your friends, your neighbors, anybody. A trust is a private document. It does not go through probate, and it avoids the time delays and the hassles. And it can keep on going. Let's say you've got 5 kids, and you want this to go for the next 20 years, because I don't want my money to be spent by these kids right away. A trust allows you to spread it out a lot longer. So you don't have to have court supervision over something for a long period of time. In the long run, it's much less expensive. In the short run, it's more expensive. In the end, you probably can accomplish the same thing with both vehicles, but it's how you want to get to the end. So, and you know, people come in and they say, look, you know, if it costs us, you know, a couple $1,000s now, we'd prefer to do it now. Or they come in and say, we're really, really tight, but we need to provide for our kids. So we said, we do a will. And then we get it, but we get to this, you know, we protect the kids, which is the number one goal, is to make sure we provide it for our children. Does that kind of make sense? Okay, it comes, a lot of times it just comes down to a cost factor.
Okay.
Trusts are more expensive.
What you're saying is the trust is more specific versus a will.
Private.
It can be a lot more specific. It's a lot easier to get into control issues. Like, you know, I want to be able to take care of my kids, and I want them to go to parochial high school, and I want to do this, because now you've got a trustee. You don't have no judge is going to make sure they're going to a parochial high school, you know. Yeah, so if you want to be able to have a little bit more control from the grave, a trust is by far the easiest way to do it. You know, yes, sir.
What is the difference in the costs between?
Well, like I said, you could probably get a will done for $700 to $1,500. A trust is going to be twice that much, you know, or in some cases 3 times that much,
I thought
depending.
you said it was, the will could be as much as $6,000 to $8,000.
No. A will's going to be between, you know, $700, $800, maybe up to $1,500 if you got a real exotic one, and a trust is going to probably start between $2,500 and $3,500. So it's a double, you know, probably.
What's cheaper
Shows the cost of probate.
than
Yeah.
either one of those?
Right, and that's the probate.
Probate's what drives up the cost of the will. Yeah, and the time consuming. It's a good year's worth of work.
$6,000 to $8,000 is the probate.
Right, 68 grand for probate, right, exactly. Yes, ma'am.
Just curious, the transfer on death instrument?
Right.
Do you need that if you have a trust?
No,
You
no,
don't?
no.
Okay.
No, you could do one, but it would be redundant.
Okay.
Even
Yeah.
for a land trust.
You could do it even, yeah, you don't need a land, if you have a land trust, you don't need it either. Yes, ma'am.
That HIPAA release,
Yes.
where would you get a copy of that? Letting me online or?
I don't know, we made our own up. I bet you there's, you know, everything's online. You know, I mean, yeah, I'm sure you can find one online. I mean, you can, I found the recipe for making a unicorn cake online. You know, it's like,
Where if I had my kids fill it out and vice versa.
right,
And we each had a copy, and God forbid something happened.
right.
They're in the emergency, they can't talk, can I read that?
We team it with our healthcare power of attorney, because at least the one that we use says, my agents that I've appointed under my healthcare power of attorney have the authority to talk to you. So it references our healthcare. So I don't know if you could find a standalone one. The state of Illinois, a couple years ago, did a healthcare power of attorney that included a HIPAA release, and they did it for a while until they found out that they couldn't because it was barred by the federal statute. So then they had to redo the power of attorney and take it out. So I doubt that you could find one that still does it that way. So, okay, yeah, yes, sir.
If I'm, where
a trust or a will here in Illinois, and then I decide to move and become a resident of New York or Michigan.
Why the hell would you move to New York? You know? I thought you were going to say Florida or Arizona. You're going to New York. You're going from the frying pan to the fire, for God's sakes. You know,
So
no.
move to a different state.
Yeah.
Is my trust or will still valid?
Yes. Yeah. Yeah. I mean, there's a reciprocity agreements with the states that if it's properly and legally done here, it'll be accepted wherever you
But I
go.
would have to come back here to probate.
No. You probate it where you resided at the time of your death. Yeah. I mean, Missouri, for instance, only requires one witness. So if a person has it legally done in Missouri and they die here in Illinois, we will accept it with just one witness. Does that make sense? Yeah. Yes, sir.
You hear the term living will?
Living will is one of those documents that is done at the time. It's a one-page people that says if I have an incurable illness, disease, judged to be terminal by my attending physician who's personally examined me, then I desire to have everything removed. So that's a living will. Yeah, it's basically pull the plug type thing. It's not a DNR, but it's just a declaration that you want you don't want to be kept alive. We don't use those too much. We use the power of attorney for healthcare that lets an agent make your decision, but that's what the living will is. Yeah.
How easy is to go online and read somebody's will? You said
I don't know that you could actually go online, but you could actually go to the courthouse and ask for a copy. Yeah.
But you cannot go online and just...
Not that I'm aware of. We can in certain counties because we have certain super secret passwords, but I don't think you can do it in Cook. We can do it in DuPage, but generally speaking, I think a member of the public would have to actually go to the courthouse and get a copy. Yeah.
My will shows per stirpies.
Okay.
It's got my 2 daughters, of course.
Right.
But then you say I should list every grandchild?
No. If it says per stirpies, it means per stirpies, so don't,
I figure it follows the bloodline.
Absolutely. Per stirpies means that if her daughters were to predecease her, her grandchildren would step into the shoes of their deceased daughter. So if she had one of her deceased daughters had 3 kids, they would each get 1/6. Her daughters get half, and so 1/2 times 3 equals 1/6.
Okay.
Make sense? So all the way in back, yes.
If you have some stock and you have a living trust so that everything goes to as many children as you have.
Right.
If they want to sell the stock, do they pay capital gains on it?
It depends. If you die, then they inherit it. They inherit that stock at the date of death valuation. By the way, there are valuation sheets in there. Fill those out. And we've got a gift certificate too, so we're going to pull a name. So if you have a, like I said, the question is, do they have to pay capital gains? It depends what the value is. I had a lady who had some stock in, Lockheed, and when she died, we got to step up in basis to the date of her death. She hit a home run because by the time we got around to selling the stock, we had a $100,000 gain from the date of death to the time we sold the stock. So we had to pay a capital gain on that, between the date of death and, that was a great problem to have, right? She had a slew of Lockheed stock. I don't know why she picked Lockheed, but, so if the stock goes up from the date of death valuation, they have to pay the capital gain on the difference between the date of death valuation and what the stock is sold for. Does that make sense? Yes. Anybody else? Okay, yes, sir.
I came in late, and I apologize if you already discussed this topic, but what kind of trust or legal structure do you need to protect your assets if you're in litigation?
Wow, this is really a good question. What type of trust can you have to protect your assets in litigation? And the simple answer is insurance. Because if you own the asset and you control the asset, it's free game, it's fair game. So if you've got an asset, you have to get it out of your name, put it into an irrevocable trust that you have no control over well before the litigation starts. Because if you try to transfer an asset, and I had to do this one time where the guy transferred all his assets, we were suing him, and he got, we took him back to court and the judge said, nice try, brought everything back, undid all of the transfers. Because you know, once you start litigation, it's SOL. You know, it's too late.
What if the insurance coverage is not sufficient, then you're getting sued for more than what you're covered?
You better buy more insurance up front, yeah. Yeah, either that or whatever asset that you control is fair game. Yeah, and that's why insurance is such a big deal. We always preach, you know, make sure you've got enough insurance, make sure you've got umbrella policies, make sure you've got all these things, because that's your first line of defense. And I don't sell insurance, but yeah, because who wants to give up control? You're a young guy. I mean, you want to control your assets. Well, you know, the only way you can protect them is not to own them. You know, so you have to transfer them to somebody else. You know, you transfer them to a girlfriend. She's going like, ha, hi. You know, it's like, you know, so you have to be very careful. You have to be very careful. Yeah.
Transfer to me. I'm a man.
Yeah, okay, yeah, she said she'll be happy to take your stuff. She says you're kind of cute anyhow. So, you know. Okay, any other questions? Fill out those forms. We'll do a drawing. Any last question? No? Okay, so anything else? Okay, thanks everybody for coming.
Thank you.